Hi, thanks for using my court coach. I'm Sarah, and I'll be your instructor as we talk about important family law assumptions concerning custody and visitation. According to Family Code Section 3020, the court's primary concern in making orders regarding the physical or legal custody or visitation of children is to ensure that their health, safety, and welfare are met, as well as to ensure the children have frequent and continuous contact with both parents, except where that contact interferes with the best interests of the children. Family Code Section 3080 states that there is a presumption that joint custody, and that means both parties' ability to have a large role in their children's lives, both physically and with respect to making legal decisions, is in the best interest of the minor child, provided that the health, safety, and welfare of the child are met. What would be an instance where the health, safety, and welfare may be endangered? Typically, that has to do with domestic violence. What is domestic violence? When a person is found to have intentionally or recklessly caused or attempted to cause bodily injury or sexual assault, or to have placed a person in reasonable apprehension of imminent serious bodily injury to that person or to another, or to have engaged in behavior involving but not limited to threatening, striking, harassing, destroying personal property, or disturbing the peace of the other, that is domestic violence. How can domestic violence impact child custody and visitation rights? Under Family Code Section 3044, if there has been domestic violence, that gives rise to the presumption that if a party has perpetuated domestic violence, he or she should not have custody of a child. The burden then shifts to the perpetrator of abuse to show that A, giving him or her sole or joint physical or legal custody of a child is in that child's best interest, and B, that the following factors on balance ensure that the child's health, safety, and welfare will be met. Those factors are completion of a batterer's treater's treatment program, successful completion of a drug or alcohol counseling program if the court determines that counseling is appropriate, successful completion of a parenting class if the court determines the class to be appropriate. If the perpetrator is on probation or parole and has not complied with the terms and conditions of probation or parole, the court will also take that into consideration. If there has been compliance or lack thereof with the restraining orders that may be in effect, the court will take that into consideration. The court will also consider any further acts of domestic violence. In short, the court needs to be convinced that even if there has been domestic violence perpetrated in the past, that the proper measures have been taken to ensure that this does not continue to be a problem that may affect a child's best interest or affect that child's health, safety, welfare. I hope you found this helpful. Good luck.